Good morning. I think everyone can hear me. Okay, great. My name is Ann Rout, and I'm the president of the board of directors of the Fair Housing Center of Southeast and Mid-Michigan. Sorry, I have a napkin. And welcome to our 8th annual Fair Housing Center breakfast. I need to move this, sorry. It's great to be back in a room with all our friends and allies and to see people live again. And I want to send out a special hello to our virtual attendees who are joining us via Zoom. This is always a wonderful opportunity where we can take a moment to celebrate our successes of the past and highlight and challenge ourselves to address the many obstacles that persist as we work to end discrimination and promote accessible and integrated communities. But first, I want to thank our sponsors who made this event possible. Do I have a list here? Oh, sorry. Just not used to being out in the real world. Okay, first I want to thank McKinley and the Washtenaw County Office of Community and Economic Development. Those are our gold sponsors. Our silver sponsors are the Bank of Ann Arbor, Home Point, PNC Bank, Flagstar Bank, and Zillow. Our bronze sponsors are the Ann Arbor Area Board of Realtors, the Charles Reinhardt Company, Fifth Third Bank, Independent Bank, Lombardo Homes, the Michigan State Housing Development Authority, Old National Bank, the University of Michigan Credit Union, and the Zingerman's Community of Businesses. Let's all take a moment to thank our sponsors. Next, I would like to introduce our founding director, Pam Kish. Under Pam's leadership, we opened the Fair Housing Center in 1992. Over the years and against an ever-shifting backdrop of funding challenges, the ups and downs of a nonprofit, changes in the law and changes in the interest of the administration to actually enforce fair housing laws. But against that backdrop, Pam has continued to lead her amazing staff to actually extend the reach of the Fair Housing Center and strengthen its capacity to actively protect the civil rights of those who are discriminated against in the rental, sale, or financing of housing. Please join me in thanking Pam as I invite her to join me up here.
Thank you, Ann. Ann is also a founding board member of the Fair Housing Center. She's been on the board for 30 years, and she's also the executive director of legal services of South Central Michigan, and we're lucky to have Ann's leadership on the board. As we prepare to give the Board of Directors Award, now called the Mark Mitchkin Board of Directors Award, I'd like to say something about Mark Mitchkin. Mark Mitchkin served on the Fair Housing Center's board of directors for over 20 years. Ted Shaw, who was leaving Ann Arbor and our board, suggested his University of Michigan Law School colleague, Mark Mitchkin, to take his place. And at the time, of course, I didn't realize what a gift this was. Mark was the best kind of board member. He worked to write and rewrite our personnel policies. He helped us make a million decisions about fair housing litigation, settlements, budget deficits, name changes, and fundraising events. He and his wife, Diane Rosenblum, gave generously, Diane still gives generously, to the organization and to and using every family occasion, birthdays, memorials, etc., as a new opportunity to give to the Fair Housing Center. Mark cared deeply about ending illegal housing discrimination, and he showed it through the time and energy and resources he shared with us. After his death in 2020, the Board of Directors elected to name the award the Mark Mitchkin Board of Directors Award. So, Mark, we miss you, and take it back to Ann.
Thank you, Pam. I'm so tall today. So I would like to invite two of the other board members who are here with me today, Delphia Simpson and Gail Rosen, to join me as we present this award. And I also invite Diane Rosenblum to join us up here.
We're going to do it on this side, so let's move over here because hopefully I turned my phone off.
So it was critical to the board that we carefully choose who would be the first recipient of this award, now named for our dear friend Mark Mitchkin. I can do this. Without question, Steve Tomkowiak is deserving of this award. While he is now the director of the Fair Housing Center of Metropolitan Detroit, Steve has dedicated his life's work to advancing civil rights. Going back to the beginning of our Fair Housing Center, we were fortunate to know that we could borrow cooperating attorneys from the Fair Housing Center in Detroit, and borrow we did. Steve was one of those attorneys who started working with our clients, and we never let him stop. As Pam described Steve to me, she said he was always willing and ready to go when she would send any case his way. Steve is one of those rare attorneys who was always willing to take the difficult cases, the ones that other lawyers would turn down. Steve's commitment and legal passion for justice resulted in settlements totaling approximately $250,000 for complainants referred just by our Fair Housing Center, so we know his reach was beyond that. I want to share some comments from one of my colleagues at Legal Services, Sarah Monroe, who had the opportunity to co-counsel a case with Steve on a significant race discrimination case here in Washtenaw County. Not surprisingly, she noted how incredibly knowledgeable Steve was about the law, but to use her words, more importantly, so empathetic and compassionate to our client and her family who had suffered a traumatic experience that was compounded by the discriminatory actions of their mobile home park that sought to evict them. She also noted that Steve was also a very good teacher, as was our friend Mark Mitchkin. While Steve is no longer a cooperating attorney for the Fair Housing Center, he continues to be our partner in fighting for civil rights as the director of the Fair Housing Center of Metropolitan Detroit. On behalf of the Board of Directors, I'm honored to present the Mark Mitchkin Board of Directors Award to Steve Tomkowiak.
Yeah, that's really nice. This is really, I don't know what to say. Knowing Mark and what he did, and I even read some other things about him. I didn't know all the work that he did. It means a lot. And, I could see where I have the same kind of desire and passion that he did. I'm not saying I measure up to Mark and all that he did, but, yeah, I do care about, people. I care about helping people. That's always been my thrust. And I really want to make a level playing field where everybody has the same opportunity, quality of opportunities. I would like, first, thank God I've prayed about my cases and clients, and I thank him for the success that I've had, and my wonderful wife who gave up many years of me working long hours at times on cases. I really appreciate her. And then I remember going back to the very early days with Pam and Mary, and then with Kristen, Nikki, Jessica, and others at the Fair Housing Center. It's always great to get a call from Pam, knowing that cases are well put together, well organized, well tested. I mean, just a pleasure working with them. Very encouraging. There's ups and downs with cases, up and down with litigation, but they're constant. I can't say enough about the Fair Housing Center here. Actually, I did more cases maybe here than in Detroit, although it's, I just really enjoyed it. One thing I did do is I didn't hit the big quote unquote cases, the large ones. My approach is everybody matters. And if I have a bigger case, which may give me some extra money, then I would use that to help people that maybe couldn't afford an attorney or couldn't afford it. So not just in fair housing, I did it in other kind of cases as well, always trying to help people. But I did enjoy the clients. They're wonderful to be with. and I did get relationships with them, and they were like friends. And sometimes I feel like a little bit of loss when the case is over because we wouldn't have that much contact talking and things like that. But it's just been a pleasure, and it still is a pleasure. In my new position, Pam, which has been wonderful to help and guide and assist. She just knows so much. And I just can't say enough. It's just a wonderful relationship. And then be here with Bob Schwem, Professor Schwem, and all the contributions that he's made as well. Just remarkable. If people need to know an area of the fair housing law, go look at his treatise. He'll have a chapter on it, and it gives people such a good foundation. So I just want to thank you so much for this. Really, really, truly means a lot. I think the world of you guys, and I think that makes it even more special knowing that you are. So thank you.
Yeah, right in the middle here. Okay.
Thank you so much. Thank you guys.
Thank you all. Our speaker today, Robert G. Schwem, is the Ashland Spears Distinguished Professor at the University of Kentucky College of Law. He began his fair housing career as an attorney with the Leadership Council for Metropolitan Open Communities in Chicago in the 1970s. This is something we have in common. I also worked on a project, well, I worked on a small project with the Leadership Council for Metropolitan Open Communities in Chicago, and that sort of led me here. He's written and lectured extensively on fair housing law ever since the 70s. His work includes housing discrimination, law and litigation. This is the book. You know, when we opened our office in 1992, we had a desk, a computer, and 2 books, and this was one of them. It's the major treatise in the field, and he's written also dozens of articles on fair housing. Bob Schwem has been plaintiff's counsel in several landmark fair housing cases, including 3 in the U.S. Supreme Court, including Mayer v. Holly, Gladstone Realtors versus the Village of Bellwood, and the Village of Arlington Heights versus the Metropolitan Housing Development Corporation. Village of Arlington Heights, any of you urban planners probably know that case. From 1986 to 1990, he was the vice chair of the Kentucky Commission on Human Rights, and in 1991, he served as a special attorney and scholar in residence with the Civil Rights Division of the U.S. Department of Justice. Please help me welcome Robert Schwem. Thank you.
Morning, everyone. I want to thank Pam and the Fair Housing Center of Southeast and Mid-Michigan for inviting me to speak this morning, and for all their work for fair housing, and to all of you for coming out this morning, and those of you who couldn't but are watching. You can tell by my age in the introduction that I go back a long way. The idea that people could see me electronically obviously was not part of my original history. But one part that I do like about my original history and thought I'd share briefly with you is my connection to Ann Arbor. I had an older brother, a very, very senior older brother with a stern, although I guess loving attitude toward me. And he went to the University of Michigan Law School. And I remember to this day being taken by him into that magnificent structure and the library, and being basically lectured on how I should behave as I went into this cathedral. And I believe we also ate at Weber's. I'm talking about 1950s. But isn't it true that Weber's had a little outfit? It wasn't this Weber's, but those are my 2 main memories of Michigan. And I've been coming to Ann Arbor almost yearly ever since because of my connections with Pam and others. Frankly, one of the great things about my life and my career is being involved with fair housing people. In Michigan and throughout the country, they are invariably wonderful and inspiring people. They have really greatly enriched my life, and I want to honor them by talking this morning about some of the developments over the last half century since the 1968 Fair Housing Act was passed, and provide a few ideas about what the future might bring. In terms of going back, the 1968 Act, the Fair Housing Act, was actually passed by the House 2 years earlier in 1966, not passed by the Senate that year, but I happened to be working as a congressional intern, a college student at 1966 for a Republican congressman who was on the House Judiciary Committee, and I got to watch the debates. I remember being up in the gallery with some famous African-American leaders watching the debates. And that was in the era, certainly true for my boss, where a number of Republicans were not only important supporters of civil rights and fair housing, but absolutely necessary. The 1968 Act simply would not have been passed without bipartisan support. And that included then Minority Leader Gerald Ford from Michigan. It's a poignant moment to think how, in some ways, that's sadly a history, because the parties are no longer even rarely joining together in favor of civil rights. But that was true in those days. And the law was passed ultimately in the Senate because of Republican Everett Dirksen agreeing to its passage. So I'm sort of charmed by that era, and yet recognize that the reason the law was passed was racial divisions. It prohibited at the time discrimination on the basis of color, religion, and national origin, but it was about race. And everybody knew it was about race, and it was about race because the nation was being torn apart by racial divisions and other divisions in the society, every bit as difficult as the ones we are facing today. Sometimes I think, I have recently retired from teaching, but up until the COVID year and the last presidential election, I used to get law students who would bemoan how tough things were. And all I could say to them is 1968. And they didn't know what the hell I was talking about, of course, as they often didn't know what the hell I was talking about in law school. But I'm going to remind those of you who were alive then, and those of you who just read about it, some of the things that were going on. We had this war in Vietnam that was tearing the country apart. We had tremendous racial divisions and ultimately urban riots. Young and old were not getting along. And it got so bad at some points that in some areas, American troops were ordered to aim their weapons at Americans. And that's pretty dramatic. I finally shut up about 1968 when COVID and the 2000 election came along, because I thought, A, they don't need to hear it, and maybe they are trumping me. But I guess the point I'm trying to make is we are not living in easy times, but we are not living in uniquely difficult times. At least those of us who work in civil rights have seen a lot of ups and downs, and you've heard some of that already in the remarks this morning. We have to be long-termers. I intend to come back here 50 years from now and see how you're doing. That's how long-term I am about it. I want to talk a little bit about the other protected classes, so-called protected classes in the law, in addition to race, although my personal view is that both in 1968 and today, the Fair Housing Act's success or failure will be judged by the degree to which it has broken down barriers based on race and has led to a more inclusive and integrated society involving race. But as you all know, thank you. I usually don't have trouble being heard. The Fair Housing Act prohibits religion, national origin, and color discrimination in 1968. It didn't include sex discrimination in 1968. It's very comparable in some ways to the employment discrimination law, Title VII, that was passed a few years before, and that law included sex discrimination. There's a very interesting history as to the 1964 inclusion in employment discrimination law of sex discrimination. It was a combination of what we might call liberals who really believed in equality among the genders, and conservative Southerners who thought it was such a ridiculous idea that if they could attach that albatross to the law would fail. It did not fail, and of course, sex discrimination claims under the employment discrimination law have been a significant area of litigation. Not so much so in housing discrimination, with one exception, and that is sexual harassment. Sexual harassment is a vicious problem, and it generally directed against poor women, and by sexual harassment, I assume you know what I mean, but it's generally a housing provider, a landlord, demanding sexual favors in exchange for rent or other benefits in housing. It's almost always directed against poor women, and many of those poor women are women of color. They are in desperate situations to hang on to their housing, often with being the only adult with children in the family. And it's the one area in the last administration, the Trump administration, that I would say the federal government continued to be useful in enforcing the Fair Housing Act. Both HUD and the Justice Department throughout the Trump administration were aggressive enforcers in terms of seeking out litigation in terms of sexual harassment. I mean, the cynic in me wants to say they were looking for something to do because they weren't doing any race cases, but they were doing that, and they, to their credit, they've drawn a lot of attention to that. Private groups like our group today, I'm sure get claims and cases, and they can help enforce those laws, but they're very difficult cases. And another point that I would make about why housing discrimination is difficult to attack is that a great deal of it involves rentals. And a great deal of rental housing in the United States is owned by very small entities. If you look at the statistic, this is just stunning to me, but about 50% of rental units in the United States are owned by people who own less than 3 rental units. They're easy to get in the business. They're easy to get out of the business. They're usually not doing it as professionals. So you occasionally will be very successful in a case, and you think maybe I've established something. Well, you certainly protected that individual, but if they just go out of business, then it's like whack-a-mole, right? I mean, somebody else pops up somewhere along the line. Now, one of the changes in the last 50 years is slowly but surely the rental industry has gotten more large and gotten more, I would say, professional. It's certainly true at the sales end with the National Association of Realtors. They've become strong supporters of the Fair Housing Act in recent years. And the times I've spoken before, what I would call professional rental agents, I've been very impressed by their awareness of and willingness to follow the law. You have a couple of cases that the local organization has done involving, for example, challenges to rental requirements that screen for criminal background checks. I know Pam and her organization has brought some of those cases on the theory that it has an unjustified negative impact on African Americans and other minorities. My view is that in the long run, the theme of those cases will succeed. Individual cases are tough, but I think because of what I would call the professionalism, the growing professionalism in the real estate, particularly the rental industry, they will learn. Large organizations are capable of learning. But it's an additional challenge of fair housing litigation, which is to say, if you did a great big case in employment against General Motors or Ford or something like that, everybody in the country who worked for General Motors and Ford would be affected by that, and almost everybody in the country would be aware of it at the corporate level. So much of our work is at the local level and at the individual landlord level that it's sometimes difficult to know whether you're having an impact. And I think the reason that an organization like this is so crucial, and there are about, I'll just say, about 50 around the country. The Fair Housing Act depends almost entirely, I mentioned the Justice Department and HUD, but it goes up and down depending on the administration. And frankly, it goes even in the best of administrations, it's not that strong. Fair housing enforcement depends on local organizations like this organization. To take in cases, to know how to do testing. I assume you know what testing means. When I was with the Leadership Council as a young lawyer, you just knew sometimes there had been discrimination against an African-American client, but if you couldn't show that the housing provider was providing better service for a white tester, there was no point in bringing the case. I may have known it, the client may have known it, but losing in court was almost a certainty if you didn't have this magnificent testing evidence. And testing is not only necessary, Steve would probably have some examples where it didn't work out, but it's very difficult to respond to. If a case is well tested, you know, the typical defense in any civil rights case is, oh, I didn't turn you down because of your race, I turned you down because of some legitimate financial reason or other reason. Oh, yes? Well, how come you accepted this white person? Oh, I didn't know you were affiliated with that white person. I didn't even know you knew about that white person. How do I explain that? Well, all of a sudden the lawyer and the judge says, maybe you should go out and talk about settling this case because it's very powerful evidence. It had to be invented. The Leadership Council in Chicago and other early organizations like PAMS had to struggle with what was good testing, what wasn't so good testing, but that's required. Here's another difference between employment. A lot of employment cases are promotion cases. And what I'm leading up to is, you know, if you think you've been discriminated against. You and your coworker apply for the job, the coworker gets the promotion, you're still there, and I won't ask for a show of hands, but if I asked for a show of hands, I'd raise my own hand. Have you ever not received a promotion that you thought you were entitled to? I would venture to say about half the people in the room, if they were honest, would raise their hand. And if it turns out to be a person who's white or male or suggestive of discrimination against you, you have two things. You have personal knowledge of what the criteria for the job should have been, and you have the time and the, I won't say it's easy for you, but your status hasn't been changed. You've got the same job. Compare that to someone who's looking for housing. They are told nothing is available, or they are told they lost the unit to somebody who they don't know who that is. But that the landlord says it was because they were more qualified or something like that. How would they possibly know whether that was legitimate or not? Plus, the very definition is, I'm looking for new housing. I may not be desperate for new housing, but I may be moving for another area. I'm not going to stop my life and inquire, at least if I don't have the help of an organization like our organization here today. So these fair housing organizations are absolutely crucial to enforcement of the Fair Housing Act nationwide. And Michigan has, for historic reasons and personal reasons, some of the best fair housing organizations in the country. The other thing I might say is that funding is always a difficult issue, but there are two sources of funding in addition to the kind of things that we're trying to do this morning. And one of them is that HUD, although it doesn't do much in the way of fair housing enforcement, has provided some grants in their wisdom, which there's no sarcasm there. I think it's the best way for them to use their dollars to help enforce the Fair Housing Act. A lot of these groups get some federal money. And then the second thing is a decision that some of you are aware of if you go back long enough, called Havens, where the Supreme Court, and by the way, the Supreme Court has been generous with respect to the Fair Housing Act, at least compared to other civil rights laws. If you follow the Supreme Court, you know that in recent years, it has not been enthusiastic about civil rights laws. and minority rights in general, and it's issued some decisions in employment and voting rights that are quite negative. It hasn't done that in fair housing, and historically, it's been very generous in terms of who could sue, including the Havens case in 1982, which said a fair housing organization, as well as the victims, the direct targets of the discrimination, may be able to sue. And your organization, I'm sure, has brought some of those cases. They're challenging in their own right, but it creates this sort of private, the phrase sometimes is private attorney general. It's a good thing we have private attorney generals, because sometimes we don't have attorney generals who are, even though they're in the public sphere, feel that enthusiastic about civil rights. I mentioned sex discrimination. Religious discrimination is another area that's covered, although that in the United States, there's been almost no litigation involving housing discrimination based on religion. The vast majority of the few cases that there are come out of the New York City metropolitan area and involve housing for Orthodox Jews, and it just hasn't migrated to the rest of the country, with, again, one or two notable exceptions. I think our group here has done some of those. One is every once in a while you'll see a minority religious person be harassed. Their neighbors don't like them, or the landlord wants to get rid of them. Harassment, whether it's sexual harassment or harassment based on other forms of illegal discrimination, is illegal. But you have to reach, like you do in sex harassment, a certain level of incidence, really, to have a cause of action, and that's difficult to show. The second area that comes up once in a while in religion is what you might call accommodations. That is, a person with a religion needs to do certain things in their apartment that they wouldn't ordinarily be allowed to do, but they can't very well live there if they can't follow their religion. And one of the tricky things about the Fair Housing Act is, and this is a distinction on the downside compared to employment, employment discrimination law requires defendants to make reasonable accommodations for religion. So that if you, for example, can't work on a Saturday, you can not be fired for that usually. That was left out of the Fair Housing Act. So you have to put together a case, either that this is intentional harassment or that there's some other problem here. And I believe in reading your literature, Pam, you have had a couple of cases along those lines, but they're relatively rare and pretty much fact specific. National origin by itself has not been a large area of litigation. A little surprising, because in the 50 years since the Fair Housing Act was passed, I'm sure you're all aware that the number and percentage of Latinos in the country has grown substantially, now exceeding by a substantial amount the number of African Americans. But there hasn't been, in terms of reported cases, and that's what I'm an expert on, there hasn't been that many specific cases involving Latino plaintiffs. The one issue that I have noticed, it goes back to the Arlington Heights case. Arlington Heights is a suburb of Chicago, and 50 years ago, they didn't allow a proposal for affordable housing, which the plaintiffs claimed was race-based or national origin-based. So the so-called exclusionary zoning continues to be a major area of fair housing litigation. Under what circumstances will a predominantly white area allow subsidized or affordable housing in? And that impacts Latinos every bit as much as it does African Americans. My hometown is about 10 miles from Arlington Heights, and I happened to be there just yesterday. An amazing thing has happened to Arlington Heights, just as a footnote. At the time of this case, they perceived themselves as a pristine 8,000 person suburb. This was about the time that O'Hare was getting to be O'Hare. They are now 80,000 people. They have apartments all over the place. They're quite integrated as far as race and national origin, at least if you include the workers at the Arlington Park racetrack, which the big news in Chicago, if you haven't followed it up here, is that the Arlington Park racetrack may be being bought out by the Chicago Bears. to build a new suburban stadium. Again, I try to avoid some cynicism and some smart-ass remarks, but I can't. I mean, that's just who I am. So my view of Arlington, and Arlington Heights is now totally on board with wanting to bid up whatever it takes the Bears to put up their $1 billion stadium on this racetrack property. And so my takeaway is that modest income blacks in 1970 were not welcome, but high income blacks with very good football skills are welcome in Arlington Heights. So it's a limited sliver of the population. But it's another example of change. I mean, the jobs were going out to the suburbs of Chicago, and I'm sure the same thing is true in Detroit. Disability. We all know that disability was added to the Fair Housing Act in 1988 and has become the #1 category of cases, far exceeding for the last few years cases based on race. Partly that is because the disability law includes this requirement of doing reasonable accommodation. I mentioned you are not entitled to a reasonable accommodation probably if you claim religious discrimination, but yes, you are if your complaint is disability discrimination. And the classic case is a service animal. But the Fair Housing Act is not limited to service animals. It also includes therapy animals. And one of the, again, I smile to myself because I've been part of a large university and I've known their general counsels for years. And I know there are a couple of cases from the state of Michigan where the potential defendant was a university housing. And the university housing said, we are not going to let you have your therapy animal. It's a service animal. We would let you have it, but as a student, you can't have a therapy animal. And here's where they got that, which is wrong, by the way. They, meaning the lawyers for the universities, probably went to a conference on the Americans with Disabilities Act. And they are very familiar with the Americans with Disabilities Act. And the Americans with Disabilities Act says, we are limited to service animals. But the Fair Housing Act doesn't limit accommodations to service animals. It includes all animals that are necessary, including therapy animals. And so you have these situations where slowly but surely, the university general counsels are learning, often through litigation, that they better be aware of the Fair Housing Act. A side issue is student housing. Academically, not terribly interesting to you folks probably because you know housing when you see it, right? It's apartments, it's single family homes. But there are these intermediate kind of places to stay where you're there for a while. Weber's rooms overnight are not housing. It's temporary, it's covered by a different law. It's covered by the Americans with Disabilities Act. But if you're talking about dormitories where someone stays for 3 or 4 months or maybe a whole year, or there have been a couple of cases, one involved Ohio State involving a sorority. And the sorority wouldn't let a woman have a therapy animal. And by the way, the judge down in Columbus just reamed the Ohio State General Counsel a new one. Get in the game here. Don't throw all these silly ADA precedents at me when we've got the Fair Housing Act. Almost everybody now agrees that student housing where you're coming back month after month after month is covered by the Fair Housing Act, and that's a significant difference. By the way, there's some sexual harassment cases involving universities as well. The other thing that universities bring to my mind, although it's a more general issue, is the Fair Housing Act has these physical requirements for new rental properties. And by physical requirements, I mean, the doors have to be a certain width. There have to be areas where you can install grab bars, things of that nature. They're just listed. They're very mechanical. They're very unusual in civil rights where you don't have to prove any intent. You just go in with a tape measure. Usually you have to say, oh, you not only did a bad thing, you did it for a bad reason. Well, you have these great big apartment complexes, and if their doors are not 39 inches, they're only 36 inches. We don't care why you did it. You're in violation of the law. And so I thought, well, if that's true for regular apartments, it must be true for dormitories. I'll give you an example of, I'm sure some of you are familiar with large universities in Ann Arbor, but I'll give you an example from the University of Kentucky. I know this will come as a shock to you, but it's unduly interested in its sports program at the University of Kentucky. So the general counsel spends most of his time making sure that the NCAA is kept away from the so-called student athletes and doesn't spend much time on other things. But we have very little money for other things, except we apparently didn't have money for building. And I'm not quite sure why that's so, but we're putting up a lot of very nice new student dormitories. And I've decided, and I have over the years written to my friend, quote unquote, the general counsel, what I call a punitive damage preparation letter, which says, congratulations is due to our university for putting up this new fancy residence hall. I so look forward to that being built in conformity with the requirements of the Fair Housing Act. Because what happens if you don't build something in compliance with the Fair Housing Act? Well, you may get sued, but it's a different kind of a relief situation than a lot of situations. Yes, there will be some kind of damages for the individual, but are you going to have to tear down the whole building? I mean, there actually was an apartment complex, a great big condominium in Evanston, Illinois, near Northwestern, that was 10 or 12 stories, and they were totally non-compliant. And the judge almost ordered the whole thing torn down. Now, why architects and builders have somewhat ignored this law, I don't know, because the relief could be draconian. So far, nobody's ordered a whole building torn down, but hundreds of thousands and millions of dollars in damages. And what they call retrofitting is required if you put that up. So if you're in the building industry or the architecture industry, or some of you are probably lenders to those folks, for heaven's sakes, don't just follow the local building code, follow the Fair Housing Act requirements. Not that tough. I mean, a doorway, 39 inches versus 36 inches. The reasonable accommodation in disability, I have mixed feelings about. It's very important. Some of these poignant pictures you saw with dogs and whatnot, it's very important from the individual's point of view. The problem from a law professor's point of view, looks out over the whole country, is what does it do to advance the law? And here's the problem. Almost every reasonable accommodation in housing case is what I would call fact-based. That is, does the individual really need this animal or really need this parking place? Some more than others. Do they really need this particular animal? Do they get therapy out of this dog in a way they couldn't out of some other smaller sized dog that the apartment complex is? And so even when you win one of these cases, and I don't denigrate it, I think every win is important. It's certainly important to the individuals. And as a footnote, I might say, I think the whole industry gets educated a little bit when a plaintiff wins a case. But they don't have to change, they meaning the housing providers, don't have to change their general policies. They just have to let this individual have this particular animal for as long as the individual is there. So that's what I mean by fact-based and kind of limited. Now, ultimately, I want to get back to race. Where are we in terms of race discrimination and segregation? Oh, I missed familial status. Just briefly on familial status, the landlords of America couldn't believe it in 1988 when the Congress said you can't discriminate on the basis of having children. Lots of cases in the 10 years after that, fewer cases today. As they say, an industry can learn. They very rarely say anymore, no children. Almost all the cases in familial status now involve one of two situations. One is what I would call occupancy restrictions. We have a 2-bedroom apartment, we don't let more than 4 people in. You're a couple with 3 children, you can't have it. That may or may not be legal. It certainly would be illegal if they're letting 5 adults in. But if they keep out 5 adults as well as a family of 5 with children, it may not be illegal. The other thing is, once we let you in, do we have restrictions on facilities like swimming pools and other public use areas? And you can visualize it. A lot of apartment complexes would say children can't swim without an adult or something like that. So those cases, again, are quite fact-based, but I think the industry as a group is twigging to the fact that this is just the law. It's not a choice. It's not a social experiment or a liberal conservative thing. It's the law, and you don't want to have a lawsuit over your your rules if you can adjust them. Health and safety requirements are certainly honored by the courts, but totally across the board stuff, not so much. So race. We know we still live in a highly segregated society, residential-wise. One of the things that I get to study is how this has evolved over time. And at the time of the law, there's a measure for black-white segregation, a 100 scale, which is 0 is total integration, what you might call salt and pepper integration, and 100 is total segregation, total separation. They have done, mainly HUD and the census people have done studies almost every decade of that number for black and white segregation in the large metropolitan areas. At the time of the Fair Housing Act, roughly the number was 80. Which is what they call hyper segregation. Very few whites live with very few blacks. Slowly but surely, that number has come down into the 70s, into the 60s. They just put out
I don't know.
For the 2020 census, and we're now into the 50s nationally. What that hides is a couple of things. That's a national number. If you take an area like Detroit, Detroit is still well in the 70 area, which is very close to hypersegregation. Same with Chicago, same with New York City. The western cities tend to be in the 40s somewhere. So, there are demographers who can explain why that's so, but one of the sad ironies is wherever the good fair housing organizations are tend to be more segregated. I don't know if it's a problem with our organization or it's just that we're drawn to the work in a place like Michigan, but there's work to be done. The other thing, and you read about this, but this is a very human story. The black ghetto of 1968 is different from the black ghetto today. And it's worse today. And the reason for that is multifaceted, but primarily concentrated areas of African Americans today, residentially, tend to be very poor. In 1968, there were middle class and even upper middle class or upper class African Americans living in black areas, and the Fair Housing Act was a boom to them. They actually, many of them moved, but left the inner city neighborhoods without much economic diversity, without role models, without a whole bunch of things that are necessary for a decent community. And then you get these studies of the modern areas of concentration that are really appalling. I mean, they have worse food, they have worse health results. I don't have to tell people from Michigan who must have followed the Flint story, they have worse air and water quality. They have worse everything that anyone would associate with a positive life. So what's the answer to that? Part of it is just good old-fashioned slugging away at race discrimination in housing. But the fair housing law is mainly what I would call a middle-class law. You are entitled under the law to live wherever you want if you've got the money. That's a wonderful theme. That's a theme that my father, who is a very strong Republican, totally endorsed. I mention him because I grew up in this small town outside of Chicago. He was on the town council. Whole town was Republican, except my mother, I think. My father, introduced a fair housing ordinance for this town in 1966. before the national law. I think they even passed it. I don't think there was an African American anywhere near the place, but it just seemed like the fair thing to do. If a person achieves in this society and gets the financial ability to move to a town like we lived in, for heaven's sakes, what do we stand for if not that that person is entitled to move up, as it were? But it doesn't directly, and I say directly, it doesn't directly address economic issues. In fact, the implication of the law is that it does not address economic issues. Senator Mondale, the original sponsor of the Fair Housing Act, was asked during the debates, does this guarantee housing for people? And he said, no, it guarantees housing for people who are able to afford it. So like the Arlington Heights case, an issue in 2021 and beyond is going to be, what is going to be the attitude toward proposals for affordable housing, subsidized housing, Section 8 housing in upscale areas. There are some reasons for hope. One is that the Fair Housing Act includes a provision that requires, if it's enforced by the federal government, it wasn't during the Trump administration, there is some evidence it will be in this administration, requires almost every local entity that receives federal money, which is, by the way, every local entity, even the richest places in America apply for sewer grants and what have you, it requires them to have a fair housing plan and to do something affirmatively to further fair housing. And that is usually, as a basic element, look at your zoning laws, look at your land use laws, and get rid of the ones that unfairly restrict apartment and affordable housing developments. So that's a positive note. Another positive note is that Section 8 discrimination is becoming increasingly forbidden at the local levels around the country. I think Washtenaw County prohibits source of income discrimination, is that right? The city, Ann Arbor does. Most of the large cities, I don't think Detroit, but virtually every large city, Chicago, New York, Los Angeles now prohibits, in addition to race discrimination, source of income discrimination. I pause so we understand what that means. That doesn't mean if you can't pay the rent, you get to rent somewhere. But that means that it's not the landlord's business where your ability to comes from to pay the rent. If you can pay the rent, the landlord theoretically shouldn't care whether it's coming from a government program or a job. And it's a very important concept, not only with respect to race, but with respect to disability. People who rely on Social Security benefits cannot be discriminated against if they have the money to pay the rent. Another example in disability in this area is, when does my government check come? Some landlords say you have to pay the rent on the 1st of the month. My government check comes on the 3rd of the month. Will you at least extend me to the 3rd of the month? No, I won't. Well, it's real easy to show if all the SSA payments come on the 3rd of the month, that particular rule has a negative disparate impact on a protected class. And the law is you cannot have policies that have a negative disparate impact on blacks or disabled people unless you have a good reason for it. I mean, if you have a good reason, if you're going out of business, if you financially need it for some reason, that's one thing. But if you just have this old rule that somebody made up 10 years ago or 20 years ago or 50 years ago, we need the money on the 1st of the month, you better be a little flexible. The Congress has before it currently amendments that would include source of income in our Fair Housing Act, in the National Fair Housing Act. That's been true for about the last 5 to 8 years. It didn't get a serious consideration in prior Congresses. It almost certainly will pass the House this year or next year, this session anyway. And then our old friend Mitch McConnell, we'll see what happens in the Senate. By our old friend, I admit that I'm from Kentucky. I want to close on kind of what I hope is a positive note. This is, as I said at the beginning, a long, long, long process to break down artificial barriers based on irrational classifications and to create an open and integrated society residentially. But there are some reasons for hope. One is housing discrimination is now at the forefront, or residential integration is now at the forefront of all civil rights people's minds. That did not used to be true. In fact, for a long time, the Fair Housing Act was considered the, quote, forgotten stepchild of the civil rights movement. Everybody was interested in employment, everybody was interested in voting, and secondarily, tertiarily, the Fair Housing Act. Now it's become clear, somewhat based on the remarks I made earlier about where people live does make a difference about their school systems and the quality of their life and their opportunities, that everything turns on where you live in terms of job opportunities and voting rights and everything else. So the national civil rights movement has gotten much more interested in what we've been interested in for decades, and that's a good sign. Another good sign is just age. And by that, I mean my generation, God help us, is dying. When I think about the appeal that some of the worst parts of the Trump presidency made, it in some ways was reduced, I believe, to old white males who remembered the 1950s with great affection. And I don't mean to be smartass about that. I mean, America had won the war. America was the place to be. Maybe not so much if you were a racial minority, but that's what they remember. And I think his promise was, we will return to those wonderful, wonderful, wonderful years. There are individuals like myself who don't subscribe to that, but I'm not so sure that we just don't need time. When I talk to my daughter and her generation, white as can be, they grew up in a white area, but they just don't worry about a racial integration the way my generation did. And the same with the African-American friend she's got. I mean, it's going to happen. Another thing is interracial marriage. I won't bore you with the details and the statistics, but it's on the rise. And if there's one thing I can take away from, say, the successful gay revolution, is you cannot, or it's very difficult to hate someone who's in your family. And the more interracial marriages we have, and the statistics are roughly 5% at the time of the Fair Housing Act and about 20% now, I think that time is on our side. So I close with the idea of, if I was in front of a Chicago audience, I'd say, well, think of the Chicago Cubs. Sure, it's been a tough 100 years. Sure, we've been disappointed from time to time. Some of us even gave up hope. And then there was the World Series. Of course, Cubs being Cubs, now they're back on the bottom, but there was that hope. And I have great hopes for what the Fair Housing Act stands for. I see people today, in my youth, I flew out one time to a Seattle gathering to give a talk. I was young and I was willing to do that kind of thing. There were 4 people in the audience and 2 of us were speakers. So we've come a long way. We've got a long way to go, but I really am confident, and I intend to be back here in 20 or 30 years to see how you guys are doing. Thank you, Pam. Thank you, everyone.
So thank you, Bob. But yeah, let's see. Let's ask some questions.
The other thing is, as a law professor or ex-law professor, if you don't ask questions, particularly those of you in the back, I'm going to call on you.
Would anyone like to start off with a question?
Pressure off the whole group,
Yeah. Also, the folks who are live streaming, feel free to add your.
Can I stay at the podium for that reason?
Yeah, maybe. Yep. Because if anyone has a question for us, they'll put it in the chat, and I'll read that in a moment. Thank you.
Hi, I'm Annie Cheslakowski. I'm the intake specialist for the Fair Housing Center in Toledo.
Hi, Annie.
We just passed source of income protection as a local ordinance. The minute we did, every lease in the municipality suddenly stated, or every application stated, you must have 3 times the income in order to rent housing.
Yeah, good point.
Yeah, which automatically just cut out a lot of people. There's really not a whole lot we can do about that because it's not recognized at a national level. Do you see that changing anytime soon?
Yes, and I would say that's the next issue. There are two sort of angles of response. One is the passage of a source of income law doesn't automatically result in compliance. And we know that from the Fair Housing Act and race, and the Fair Housing Act and familial status and everything else. So it's going to take time for this to seep in. The other thing is, and to reinforce that, Chicago has had a source of income law, or Cook County, I can't remember which, for at least 20 years. And they have published their own administrative law judges' decisions now in these cases. And first of all, most of their cases now are source of income cases, indicating that the landlords are slow to pick up things. And second of all, some of them win and some of them lose. And the landlords who win say, well, it wasn't source of income, it was something else. And I take that to be your question. They didn't have enough income. 3 times is not an unusual thing, and that's our standard. So my view is that that will be next. There are a few cases, not many, but a few cases that challenge a time, what would you call that? A ratio, a required ratio. And it depends on the statistics, but a very, very sympathetic situation would be a disabled person, which is to say, you know this income is going to come forward. Actually, the Social Security Administration and HUD has sent out statements that say, you, a provincial housing provider, cannot question the ongoingness of SSA payments. That was another thing. We demand that you be working to get your 3 times income. You can't do that. But I don't underestimate the fact that if this law is new in Toledo, and when, as, and if it becomes new nationally, it's going to take 10, 20 years to seep down and get observed. And you have to keep in mind that, and I guess I'm speaking to myself here, landlords have the right to be assured, or at least up to a point, that they are going to be paid. If you don't do that, everybody's going to get out of the business and you're going to have fewer units. So it can't be just all landlords are bad and there can be no checking requirements. So we're going to struggle with what's required, but I do believe that the next layer of litigation will be a ratio challenge, and we'll see. It's a very, very sympathetic case if it's someone on disability.
Question over here.
Hi, I was wondering if you had seen an uptick or a lot of action with respect to LGBTQ
Yeah.
community?
I'm glad you asked it, because I did have that in remarks and I skipped over it. This is clearly now illegal under the Fair Housing Act, based on the Supreme Court's interpretation a year or so ago of Title VII, right? Gender or sex is the word used in the law. It was interpreted by the Supreme Court in the employment discrimination context to include sexual orientation and gender identity. I haven't seen a lot of cases yet, but HUD, early in the Biden administration, put out a statement that say, we believe our law, meaning the Fair Housing Act, is absolutely the same as Title VII, which means that it is now considered a Fair Housing Act violation. The only times I've seen it prior to that Supreme Court decision is in what I would call a harassment case. There's a case that I believe originated in Indiana. Anyway, it was the Seventh Circuit that covers Indiana, Illinois, and Wisconsin. And it was a retirement community with 2 lesbian women, and they were being harassed by their neighbors. The case was defended on the grounds that we're not discriminating on the basis of sex, or our tenants who are harassing you aren't, but the Seventh Circuit rejected that. And its opinion is now, I think, the best out there. But I don't know how much discrimination there is. There have been a couple of studies based on phone inquiries that suggest there's some discrimination. But the short answer is we don't have much experience in that area yet. I'd be very, very interested to see how that goes, because I tell you, one of the ironies of this is that when I was practicing law, we did have some gay men clients, and the landlords loved them. You know, the stereotype from the landlord's point of view is that they would be much better than if they were otherwise, because they took care of the place. You know, it was a 50-year-old stereotype, but it was kind of helpful to our clients. So do you have any experience with that? Yeah, but it's another one. You know, one of the things that I've been really blessed about, I mentioned at the beginning, the people in this business are just inspiring and wonderful. There's always something new. I mean, race discrimination in an apartment complex, that was going on in 1970, that's going on in 2021. But there is always something new. And I didn't get a chance on another area, internet advertising. Just to say it is to recognize that when the Fair Housing Act was passed, they had a provision that said it's illegal to discriminate in your advertising. Well, what would they think about newspaper ads? That's how people found housing in 1968 and 1970. I'm not letting any cats out of the bag that if you tell the younger generation, why don't you go look in a newspaper for your next apartment, they just laugh out loud at you. I mean, it's all on the internet, right? And there have been some interesting, tricky issues about how the Fair Housing Act applies to the internet. One other small example, this is a Chris Brancard story. A famous fair housing lawyer, is about 50-ish, out on the West Coast, had an Asian American associate. And one day, they each used different computers. One day they decided to inquire, this is about 5 years ago, about getting a new house in the Chicago area. It was a total test. And using their each individual computers, they asked for exactly the same thing of I don't know whether it was an internet provider or whether it was a real estate agent who had a website, but they got substantially different listings. And when they thought about it, it was because you know what your computer says about you. Everything. It knows what you bought. It knows the magazine subscriptions you use. Frankly, it knows your race, color, creed, national origin, and everything else about you. And the old view of the real estate agent, I'm proud to say, I think a lot of people are beginning to get over it, was it's steering, that's what it's called, right? I mean, you steer white people to white areas and Asian people to Asian areas and black people to black areas. It was just efficient. That's where they'd be the most comfortable. Why would we waste our time showing white people houses in minority areas? Why would we waste our time showing minority people? Why would we waste their time? Well, it's somehow built into some of these databases. So I've used your question to suggest that there are always going to be kind of new, interesting issues. And the Fair Housing Act, we know what it wants to do. It wants to give everybody the same treatment. But it's challenging in kind of fun ways from a professor, and maybe not so fun ways from a practitioner. Are there others?
While people are thinking of other things, I have a few that came in on the chat. What is the correct response for the question, do you accept Section 8 if we do not?
Well, I think the correct response depends on the law, and there is no national prohibition on that form of discrimination. Let me pause by making a general comment. Discrimination is good. Did I wake some people up who are falling into their cold eggs? Discrimination is required to survive. If you can't discriminate between food that's good for you and poison, you will die. Human beings discriminate all the time, and thank God for it. So, the Fair Housing Act and other civil rights acts are limits on the type of discrimination. But apart from the specified areas, and so far Section 8 discrimination is not covered by the national law, the implication is that any housing provider is permitted to discriminate on that. Now, the tricky thing is you better check, or you better make sure that that's true with respect to your localities. I know Grand Rapids, you said Ann Arbor has source of income. The big cities all have source of income. So my answer would be it depends. The other thing is, if you want to be forward thinking, if I was talking to someone who was not just a mom and pop landlord, but a large apartment complex, I'd say, why do you want to do that? And there are some legitimate reasons. I mean, if you take Section 8, folks, you have to subject your apartment to some inspection requirements that might take a while. So it's not totally irrational. But if you can't come up with anything other than, well, my father owned this apartment 25 years ago and he said, we don't want anyone on welfare, then you're in trouble. And that's the whole theory of these impact cases, right? I mean, there are successful Fair Housing Act impact cases challenging source of income on the basis of race and disability because the protected group is disproportionately harmed.
Thank you. The next question I have, a little bit longer. When we have the ability to require landlords to meet specific standards for affordability, and in particular eligibility, what are the best practices? For instance, not 3 times the rent in reserves, but also related to credit scores and other ways applicants are ruled out rather than ruled in.
Well, it's an excellent question. And I think this is where we need help. I mean, legitimate help from what I would call the industry. The earlier question about led me into this idea of, could you challenge a ratio requirement on the basis of its impact on a protected class? And that might be source of income or it might be race. And here's the thing about this impact theory. I know some of you know about it, but it's not impact in the way that we use the word in English. It's a specific theory, and the key part to my answer is, if the plaintiff shows that a policy of a housing provider disproportionately harms a protected class like minorities or disability people, that's only part of the case. The second part of the case is then the defendant isn't automatically liable, but the defendant has the opportunity to show that there's a legitimate reason for that requirement. That's where I think the trickiness will come in. And I think initially judges will say, well, if just the instinct is, of course the landlord has to have some requirements having to do with how much income you have. What the industry and the fair housing advocates have to figure out is, are there alternatives to help landlords do what's legitimate, which is to make sure they will be paid. I mean, it's easier to talk about disability because there's a requirement of accommodations, but there's a famous case out of California about 10 years ago now, where a landlord had a financial requirement and the disabled person couldn't meet it, but the disabled person's mother came in and said, I will guarantee that he will pay the rent. I will sign whatever documents you want. And unfortunately for the landlord said, that's not good enough. We also have a policy against co-signers. And after the Branchards and the Ninth Circuit got done with that landlord, they were sorry they had said that. But the judges recognize that landlords and housing providers have financial concerns and interests. But what they're looking for is this the only way you can do that? Are there other ways that you can do that? And that gets pretty fuzzy at this stage because we're in new ground, but we'll learn.
Thank you. Does anyone else have a question in the audience or on the online chat? Really, no questions? I'm surprised. Oh, there's one.
Well, I must say it's a very, based on the questions, they're very sophisticated questions.
So you've talked a lot today about rental housing, but I haven't heard much about home ownership. Is there any interesting developments in Fair Housing Act as
Yeah, a
applied to home
couple.
ownership?
Thank you for asking, as the politicians would say. Maybe I salted that. Steering is still the #1 issue. I don't think any real estate agent looks at a minority candidate and says, I won't deal with you. Some of you may have heard of a report that came out of the Long Island suburbs of New York about 3 years ago, published by Newsday magazine, or Newsday newspaper, which sent out 100 different pairs of testers, whites and blacks, whites and Asians, whites and Latinos, to individual realtors. And what did they find? Well, some realtors did a terrific job of treating everybody exactly equally. On the other end of the spectrum, there were quite a few who sent, and you understand what good testing is. They ask for exactly the same thing. We're looking for I guess in Long Island, you have to add a little zero to it, but I'll make up something. We're looking for a $400,000 to $600,000 home within half an hour of this particular retirement home where my mother lives. And the bad news is about 50% of the white-black testers had substantial evidence of steering. Now, the good news is that at the National Association of Realtors level, and I think in many other levels, local levels, realtors are getting very, very much different than their predecessors. Again, it might be just an age thing. But the National Association of Realtors 2 or 3 years ago hired an African-American man who had a long history of fair housing enforcement. And their leadership and he have done an incredible job of putting out positive fair housing things, including talking very candidly about steering in this Long Island study. So it happens. That is to say, discrimination happens. A couple of other examples that the Long Island study showed were on the bad side. Again, there were 100, and they weren't all showing discrimination. There was actually some inspiring equality being shown. But a black person would come in, and one realtor would say, well, you have to be pre-qualified. You know, I'm talking about there, you have to have a bank or a lending institution that's already said that you can afford the $400,000 to $600,000. They wouldn't apply that requirement to whites. Or they'd have other little hoops that blacks had to. And the other thing is that they, without being explicit about race, of course, you don't have to be, right? You say, well, this is a school district you really don't want to be in. They would say that to the whites. They wouldn't say the same thing to the blacks. Well, what can you infer about that school district? It's heavily minority. You really maybe don't want that side of the expressway because the crime rates are up. So crime rates, schools, a few other dog whistle kind of phrases are still out there. To its credit, the licensing organization in New York State got a hold of this stuff and have now sued 3 or 4 of the more egregious examples to take away their license. And as you probably can guess, the state licensing agencies have been quite pro-realtor over the years, and that has generally meant, I don't think I've ever heard of a realtor lose her or his license over Fair Housing Act violations. The other thing is that the what's called fair housing testing that you have to go to, or fair housing education is better, or on the verge of getting better. I mean, in their undercover investigation, they took people with microphones, hidden microphones and hidden cameras into some of this fair housing testing. I'm sorry, training, I keep misspeaking. And it was a joke. I mean, it was a joke from the guy in front of the podium. Maybe people were legitimately trying to find out what the Fair Housing Act required, but it was just a joke. Well, in New York, I don't know what the law is in Michigan, but in New York, you can record people without their knowing it. I say one-way recording is legal. And so that, I think, is helpful. The NAR and its leadership is helpful. There is hope. I get now, I'm on staff, I get a little money to advise the NAR, and they say, well, we want to set up like a question, and they're amazingly, quote, liberal, unquote, questions. So I'll give you a couple of examples. Some years ago, HUD said it was all right to use the phrase master bedroom. I thought that was the law because HUD has the power to interpret the Fair Housing Act. Well, a lot of young realtors say we don't feel comfortable, white or black, using that phrase. So you will see, in my judgment, if you haven't seen it already, that the phrase master bedroom is an anachronism and won't be in ads anymore. It'll be premier bedroom or whatever it is. Just in the last 2 weeks, his or her closets, his and her closets. Maybe it's a her and her. I've got a nephew who's what I would call a strong gay rights gay person, and he wants to be there. My mother was an English teacher, and I'm of the generation that I don't want to call an individual there, but he says if I want to be his friend, and I do, I have to start calling him there or something like that. So that gives you an idea. There's hope, and part of the hope, and I would like to apply this to the rentals, is it's a profession. And ultimately a profession will figure out what the law is and try to obey the law. The other reason I probably stress rentals is if you look at the statistics of Fair Housing Act complaints filed nationally with HUD and local agencies, the overwhelming number of them are still rentals. We could get into financing of housing. Again, I think the financial industry is learning. It took some of them a long time, but they're learning. The home insurance industry is learning, partly because of some Toledo cases, I might add. There's an issue out there now, maybe you've read about it, about appraisals. A very egregious individual cases, but the appraisal industry says, we don't know whether this is widespread, but it's roughly, if you haven't heard of it, I mean, it's a black trying to get his house appraised, and the first time they get a very low appraisal, and then they take out all the pictures of their family and bring in a new appraiser, and it's $100,000 more. Wow, yeah. But the problem from a national point of view is that some kind of an aberrational, silly old crazy appraiser who did the first one, or is that a serious national issue? And that's another fun thing.
Thank you. We have another question from the online chat. Should builders modify their plans for religious requests, for example, a prayer room, to stay compliant with fair housing law?
I don't think they're required to, if I understand the statement. So I would say the short answer is you're not required to on religious. The only physical requirements in the Fair Housing Act are disability requirements. What you do see from time to time are, well, my parents ended their lives in what was called the Presbyterian home. They weren't Presbyterians, but I venture to say there were no Jews in this retirement complex. At the retirement home industry, you see a lot of named situations like Roselawn Catholic Home or something like that, or a Jewish home. And then the question is, even if they allow people other than their religion in, can they continue to do just kosher foods or something like that? I mean, will that have a negative impact on the non-Jewish population? Or what if we have a chapel where a priest shows up every once in a while? And we have Protestants and we have Jews and we have Muslims, but we only have this one facility that regularly has a Catholic clergy. I haven't seen litigation. Most people, don't go that far. Maybe we're giving a pass to retirement communities because after a while, you can't do anything about old people, right? But I do remember at the time my parents went into that place, and this is when the disability law is just passed in '88. They were required to take a physical. And the idea of the cost structure was what was called bundling. We have regular living, independent living, we have then kind of you move into full care, and we don't want to take people who are sick at the beginning. I mean, we know you're 80 years old and you're going to get sick if you're lucky enough to live. By the way, that's a fun footnote. If you're having trouble being sympathetic to people with disabilities, just realize that you can only hope you will become disabled, because the alternative is you will die young. I mean, we're all going to be disabled if we're fortunate enough. Anyway, I scratched the back of my head and I said, I don't think they can do that. And my dad said, shut up. We can pass this physical. We want to get in this place, We don't need a lawyer here. We need you to shut up. And I said, that sort of bothered me. Shut up. But I will say this, that cost structure has changed across the nation industry-wise. Nobody bundles anymore. Nobody, I think, requires a physical. You pay for what you get, and if you need special care, we can't discriminate against you, but we can charge you. So on we go.
Right, we would have time for one quick question, but anyone? All right, thank you so much,
All right, thank
Bob.
you. It's really wonderful.
Thank you all for being here today. Thank you to all our volunteers and staff and all our sponsors and just community members. Thank you so much for being here.